Welcome to Faith in Real Estate. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist serving Georgia, Florida, and Alabama. Welcome to my channel. I am so excited, want to be live today. And next, I'm excited because I have a special guest with me today. We are talking about the Alabama probate process, and I have attorney Jack Carney here today. If you want to go ahead and introduce yourself, Jack.
Yeah, thanks, Wanda. I'm Jack Carney. I practice here in Birmingham, Alabama, and estate planning and probate attorney.
Awesome, awesome. So we're going to go ahead and get started. Again, we're talking about the Alabama probate process. And so for those of you that follow me, I know I try to make sure that I'm providing content for all three states. And so again, today specifically, we're talking about Alabama because every state has different laws. And so if you can kind of just give us some insight, Jack, on the probate process.
Yeah, absolutely. And probate can be quite a scary word. I know a lot of clients feel that way when they hear it. And it's also a misunderstood term. And so part of what I hope we do today, just give people a little more information about what probate means. And to me, probate is simply the process of taking assets that are in the name of a deceased person and transferring those assets to another individual or individuals. And sometimes that's pursuant to a will, but as we'll talk about, there may not be a will. So if you think about it, when someone owns assets, I have the power to transfer those now. If I'm deceased, no one legally has that authority anymore unless we go through probate.
Awesome. Awesome.
And so, one of the good things or good starting points is to talk about, when somebody passes away, which again is a very difficult time. It's a very emotional time. And now you have to deal with legal matters, and that's very difficult. And so one of the first steps I talk about with clients is, do we have to probate? When we think about a process, let's not jump right into the process. Let's talk about, do we need to even go to the process? And I think that's often misunderstood. People may have a will and they'll come to me and say, well, I've got this will here. I need to file it for probate. I said, well, we might have to, but let's talk about it. So the example I use is assets can pass to another individual outside of probate. And so one of the questions you have to ask when you have somebody who passed away is, do they have any assets in their name that we can't otherwise access? If so, we may be required to go to probate. And a good example might be a married couple. If you're married and you own your home jointly with your spouse and you have a joint bank account and your spouse is named as the primary beneficiary on your retirement and your life insurance, you probably will not need to probate at the death of that first spouse. Everything passes automatically as a matter of law to the surviving spouse. So our first analysis is, do we even have to probate?
Okay. So once we determined, okay, do we have to probate? And we do have to probate. What is the first step?
Great. Yeah. The first step for me is to determine, say we have a house that's in somebody's name and it's in their name alone. And we there's no alternatives to probate, because sometimes there might be some alternatives. But then we have to determine, does this person have a will? Do they have a last will and testament? Because that is a document that dictates their wishes when it comes to the passing of their assets. So that's question number one, is, do they have a will? If they have a will, or even if they don't have a will and we determine we have to probate, we file some documents with the probate court. And that's a special court in each county in Alabama. Most states are like this, that handles the administration of a decedent's estate. And so if you are died in Jefferson County, Alabama, and you are a resident here, we would file your will, for example, with the probate court of Jefferson County. That's another an interesting point. People might have a lot, they have a will and somebody may pass away and they think the will has some authority. And so I usually tell folks the probate process is to determine which will is the will that has authority. So if you think about it, somebody may have several wills that they've done during their life. They may be very different.
Mm-hmm.
Probate can be a good process because it tells us through the court process which will is the one we're going to have to follow.
Awesome. So let's talk about that. If they have multiple wills, I'm assuming the most recent will is what would be.
It is the most recent valid will, because Alabama law says, and this is important determination, and sometimes in probate, when you sign a new will, you revoke any prior wills that you have.
Okay.
So
Now,
sometimes, yeah, go ahead.
I'm sorry, I was going to say in Alabama, a valid will is notarized, and what is that process?
Yeah, it's a great question. It's worth talking about a will for a few minutes because it's so important. And as we'll talk about with probate, it makes that court process easier when you have a will on many levels. And so a valid will in Alabama generally is a disposition of your assets. It's the intent to make a will, has to be signed by the testator, the maker of the will, and witnessed by two people.
Okay.
Notarization is not a requirement to have a valid will in Alabama. However, if you have a self-proving affidavit and if it's notarized, you do not have to have your witnesses come testify in order to probate. So that saves you a few steps in the process. So 2 witnesses is all that's required when someone signs a will.
Awesome. So, and I know it can be a lengthy process, but just to summarize, you said we're going to determine if they have to probate. And if they do, they're going to file the petition. And then from that point, what happens? Is it, I know in some states they file something in a newspaper. What is the step?
Yeah, let's talk about that. I'll talk about more kind of stick to the will and in that process and understanding it. Because I want to take a little bit of the fear out of probate. One thing to understand is in some states, probate can be more involved. Probate can be more expensive. There might be statutory fees and taxes related to probate. It's not really the case in Alabama. There may be reasons to avoid probate in Alabama, but probate is not the same process that, it's not the terrible process that most people think it is. Now, granted, in some families, you could have a terrible process going through probate, especially if you don't get along.
That's true.
But you'll hear about those stories. But in general, it is a far simpler process. And I think it's a pretty good process to go through. So what happens is you'll take the will, you draft a couple of petitions, and the person we're interested in talking to is the executor of the will, called a personal representative these days. Those terms are synonymous. That is the person who has a duty to probate the will if they know about it and to produce it. That's the executor. So they sign the petitions. And Alabama law says you have to notify the heirs, the next of kin, whenever you file a will. And if you think about it, to me, that makes sense, because if the will is invalid, and there is no will, then the heirs are the ones who take the estate. So hence you have to give the heirs the chance to see if there's a problem with the will. And so one reason you might want to avoid probate is if you have a lot of heirs or you can't find some of them. Because in order to probate, you have to notify them somehow, and preferably to get them to sign something. Now, if everybody signs off on it and everybody's an adult and everybody's competent and they sign off on the petition, let's just say it's a family with just 3 kids and they all get along. Each of those children will sign a consent to the filing of the will. The will is filed with the court, and almost immediately the court will, without a hearing, if everybody signs off on it, the court will issue a document called letters testamentary. Letters testamentary is now the authority that the executor has to access the assets of the decedent. So I had a client once that says, "Oh, it's like a Willy Wonka golden ticket." Is letters testamentary. That's exactly what it is. And so a lot of times people will come to us because they go to the bank. They're trying to access mom's account. She passed away. Banker tells them, "I need letters testamentary."
Right.
And so they'll come to us and they say, "I need some kind of letters document." And at that point, we generally know we might be looking at a probate because now they have authority. They have authority to access and gather those assets. So that's That's the first step in the probate process, is getting authority, because really nothing else can happen until you have letters in hand.
Mm-hmm. Awesome. Awesome. I know a lot of times people don't understand they need the letters and they are trying to do certain things that they do not have the authority to do. So I'm glad you covered that.
It is, and even from your world, it'll give you the opportunity to sell the home. Especially if the
Absolutely.
will has a power of sale, you're going to need letters testamentary in order to transact legal business on behalf of the estate. So I usually tell folks, we might, and this is maybe just a good in kind of working through an estate. If you're having to handle it, the entire focus at first should be on getting letters,
Mm-hmm.
because nothing else happens without it. And the other parts of the probate process will come in time, but the granting of letters is step one. And then that actually starts some timelines that are important. So, for example, one of the first things an executor may do is notify creditors, notify people that might have a claim against the decedent. Part of the probate process is to not only gather your assets, but it's to settle all your debts. And so when you get letters granted, there is a 6-month claims period. And that is the time in which creditors can make a claim against the estate. That time period starts with the granting of letters, not the date of death.
Mm-hmm.
And so it's important to go ahead and get that timeline started. And the executor has a job, has a duty to notify creditors that they know about and basically let them know in writing, if you have a claim against this estate, if you think this decedent owes you some money, you need to file a claim with the court. The good news for the family, and this is one of the advantages of the probate process, if the creditor does not file a claim within that 6-month window, they're forever barred from bringing a claim against the estate. So it's a good way to give families some closure. Now, that 6-month bar may not apply if you knew about the creditor and didn't tell them. So it's important to tell them. That's a big part of the process. Let them know if you have a claim, file it, and then the executor can assess, is that a valid claim? Do we have to pay it? So that's part of that administration phase of probate. If we're talking about, there's opening, we'll talk about closing in a minute, but then there's the administration phase of handling the business, dealing with debts, funeral expenses, gathering assets, selling the home if that's something that needs to be done, handling business.
Mm-hmm. Awesome. So I'm understanding that the probate process will take at least 6 months then because of that time frame.
It does. I mean, I think you could say, just as a matter of law, the estate has to be open for a minimum of 6 months.
Okay. Awesome.
To allow for the creditors to make a claim. And you did mention too, the court will publish notice, and that is meant to apply for unknown creditors that the decedent's family or the executor may not know about. That's how the court handles that. They put it out there in the paper, basically saying this person passed away. Here's the case number. If they owe you money, you need to file something in the court.
Mm-hmm. Awesome. All righty. So, is there any other process that you want to talk about with any other step?
Yeah, I think it might be kind of start thinking about, when you talk about closing the estate, because I look at probate as just a process. It's just a journey. It's handling business from beginning to end and kind of handling somebody's final affairs. What I usually recommend to folks is when you open the estate and you have 6 months, don't necessarily wait until 6 months to start closing the estate. Even though you can't close the estate for 6 months, it's probably a good idea to start thinking about how you're going to close it as early as you can in the process. That'll save a lot of time, and that will prevent the estate from lingering and staying open too long. And I think one of the other things, sometimes it's a common mistake is folks forget about taxes in an estate. So when you're the personal representative of an estate, you're responsible for filing the final income tax return of that decedent, if one is due. And you may need to file an income tax return for the estate itself as an entity. And so we just encourage people before we close out an estate or as we're moving towards closing, maybe talk to a CPA or other tax professional and just determine what do you have to do before we close?
And I'm glad you said that, because I actually did a video where I interviewed a tax representative, because people people think they don't need to pay those taxes, but you do. Yes.
It is, and the IRS is they don't really care about that whole 6-month claims period. They kind of do what they want. They have their own different rules. Federal law kind of trumps everything sometimes. So you want to make sure you clear up the taxes. Oftentimes it's an opportunity where we sometimes have estates where we realize the person did not file taxes in the past several years, and it may be because they've been suffering from a long-term illness and they didn't file anything, and it's a good time to kind of the executor can clean some of that up. And again, what another good way to give the family closure, handle all the tax matters before you close out the estate. But an estate is eventually, you're moving towards closing. And to me, if we're kind of looking at the entire process of a kind of a macro view, closing is getting the assets from the name of the decedent to the beneficiaries of the estate. And so at the end, if kind of how we started, you can easily close an estate if everybody agrees to how it was administered and that their share is what they believe they should get. So at the end of an estate, ideally, we like people to sign a consent, basically saying that they're happy with the estate administration and that they're happy, are content with how the executor handled things.
Awesome. So I do have a question for you. What are some common mistakes that you have experienced with clients?
Yeah, I think one initial common mistake, it kind of goes back to what we said before. It may be probating or opening an estate. So a lot of times we say probating a will. Sometimes you have to open an estate anyway if there is no will and there's assets. But I've seen a mistake where people will probate or open an estate and there was no reason to do so. So you might have no assets and a lot of debt. And then somebody might file a will with the probate court, and that may not be a good idea in the end. Sometimes there's other reasons you might want to open an estate. But to me, unless you're pursuing some type of litigation on behalf of the decedent, or unless you have an asset that you are trying to access, you don't want to maybe do that premature probate. And just because you have a will doesn't mean you have to file it. So that's an important thing. I think that's a common mistake. And then I think not having enough information about the estate is another common mistake. And that can lead to a lot of issues. That could lead to closing an estate too soon. We've seen that sometimes where we will go through the entire process, we will close an estate, and then the executor 6 months later might discover yet another asset.
Wow.
And so it's good when that happens, but it also requires that we reopen the estate. And it's not a terrible process, but it's nice to avoid it. I think a lot of the mistakes can be cured on the front end by doing good planning. And I always encourage people, even if you do a good estate plan, have a good record book, have a good summary of your assets. Make sure that your family knows where everything is. You don't have to tell them now. I don't think you should tell them now, but you should at least put it somewhere. And I have seen those estates where someone has it so well laid out that the process is so easy. Wow. And I can just remember I had a client who was just raving about her father who died probably a decade ago now. And she was just saying how well organized everything was. He had every asset and account number listed in a binder. It was all very clear, step by step laid out what they were to do. And she was just going on and on about how wonderful that was and how great he was to do that. And my only thought was, wow, what a nice way to be remembered by our loved ones. Instead of your loved one maybe saying, gosh, I love them, but they left me with a mess. I didn't know where to start or what to do. And it's been a hassle. So we can make it a lot easier for folks on the front end by being reasonable. It doesn't have to be too detailed, but just reasonably diligent about listing assets and financial information.
Awesome. So we should create a binder with all of our information to make it easy for our family when we pass away.
You can, and I've had some client that said, I'm gonna make it black, and it's gonna be my death binder. And I said, well, why don't you just make it yellow and make it a little happier? It doesn't have to be black.
Right.
But any information is such a valuable tool during the estate administration process, because one of the things we started doing when we administer an estate, and this is something I would encourage everybody to check, is we've been going to Alabama unclaimed property and surprisingly finding assets that belonged in an estate.
Wow.
Where people, maybe they moved, or they were getting a dividend check or a check from the state, and they never cashed it. And so that eventually gets turned over to unclaimed property. So maybe one good thing to do is, just before you close, check unclaimed property. We had an estate where we found a 6-figure check on
Wow.
unclaimed property, 6 figures. So, because somebody had a large bank account and they were very sick at the end, and things just get away from you. But that and Wanda, I actually was showing somebody how to use unclaimed property once, and I found my own name on unclaimed property. Now, granted, it was not 6 figures; it was $60, but it was a refund from Charter Internet. And they had the wrong address, and so it went to unclaimed property, and but it was $60.
That's right. Hey, $60 is $60.
It's $60, absolutely.
Yes, yes. Let's see. What is my next question? This is such good information. If you're watching, please share the video. Let's see. What tips do you have for families in probate?
Yeah, a good question. I think it's more of, number one tip is share information and be transparent if you're working together as a family, and particularly if you're the executor. Because going back to what I said before, if you're beginning with the end in mind, which is something Stephen Covey would say, you want to begin with the end in mind. We want to have a closure of the estate that's done by agreement. Well, if you want to get somebody's agreement, maybe your sibling, I would advise people to make sure you keep them posted and apprised of the progress throughout. So, for example, you think about the difference. If I tell you throughout the 6 months what I'm doing and how much I sold the house for, and I'm giving you all the facts, you're going to feel a part of it. You're going to feel connected. But if instead I don't say a word to you, and in about 7 months I say, Wanda, your share is $100,000, sign here.
Right.
You're probably going to have some questions, and you probably should. So I always tell people, be open, be communicative. The executor has a duty to do that. And what I tell executors is, you're a fiduciary. That's a pretty high responsibility. You should be absolutely transparent. And because, again, there's nothing to hide. It's just a process. And so I think that would be one. Two, another tip would be just being organized. That helps us as the lawyer too. If you just kind of gather everything, even if you're administering an estate, keep it all in one estate binder. Have it all together. A couple other tips that come to mind, legal fees are a big thing. People talk about legal fees. I don't pay lawyers, and I understand that. I don't like to pay. I wouldn't want to pay a lawyer either to do something like this. But there are some ways you can reduce that by, lawyers bill for their time. And so I had an estate once where it was a large family, and every member of that family was contacting me at various times, all asking me the same questions. Well, that was taking time. That was increasing the cost of the estate administration. So I suggested that perhaps you all agree on a family spokesperson. And maybe instead of emailing your lawyer every day, you email maybe once a week and summarize the questions. Right. And I guarantee you that will result in a reduced cost because it's just less time. And I think people appreciated that because, again, I said, I'm answering the same question, and you're still going to get the same answer. So there are some things with just being organized and communication with a family. You can really make it an easier process.
Yeah. I always suggest that in the probate process, the families have family meetings, even if you do it by Zoom. For those of you that are watching, maybe if there's a member that's in another state, but it's good to have family meetings during the probate process.
Well, and there are times too when, you might have to make some decisions about dividing assets. You might have to make a decision about selling the home. And in certain cases, you might need to get the consent of the heirs. And
Right.
so again, talking about that, trying to get that understanding and having that communication is important. And I think another tip, you think about the probate process again, there's a lot that goes on. It makes me think about the dividing of personal property,
Mm-hmm.
things. I think what I usually tell families is the number one area of dispute I've seen in 20 years. The number one area of dispute is the division of personal property, like wedding rings, pictures, furniture, stuff, guns, hard to divide assets. And so
Mm-hmm.
it's very important to have a conversation and maybe a good plan about how that's going to be done on the front end. And even mom and dad, before when you're doing your estate plan, I usually recommend a list, giving your family some direction about how you want to divide your personal property. Because mom only has one engagement ring, dad only has one wedding band,
Mm-hmm.
dad's got 5 kids. What's going to happen?
That's
Um,
good.
and so you don't want that type of dispute with your family over stuff. And I think most of us agree um, on that line. So that's a big part of it. And the other tip is let the beneficiaries talk about it. And, for example, when families are dividing personal property, I encourage just the children, if they're the beneficiaries, to meet. A lot
Mm-hmm.
of times I found that maybe the children bring their spouses, they bring their kids, they bring their friends. I've been in meetings where we had no room in the conference room because everybody brought a posse. and just again for support, and I get that and understanding, but I also think there's a little bit of, if I bring more people with me, I'm gonna
That's right.
I'm gonna get my way. And so I try to encourage folks and clear the room. This is the kids' business. Let the kids talk. Let the kids talk about it. So those are just some good things that I've seen that help reduce some dispute.
That's a good point. Let's see. My next question is it worth trying to avoid probate?
I think that is a great question. And I have a typical lawyer answer that people don't like. It depends. It depends on your situation. Um, and so if you can avoid probate, that is not a bad thing. But we have to look at how does one avoid probate? And what are the consequences of avoiding probate? Because one of the things we just kind of went through is we have a very regimented, tried and true system to handle estate business. Sometimes when you avoid probate, it could get a little murky, and a lot of the protections are gone. So let me give you a good example of when, and then I can tell you about some ways you could avoid probate and at least look into it. That's what I would say. I mean, it's worth looking into. Well, first of all, when you have a married couple, you've probably avoided probate anyway. I mean, depending on how you title your assets. So again, if everything's jointly, you've already avoided probate. Sometimes when I have maybe a single person and they're a little older, maybe they need some help with managing their money, we might talk about something called a living trust. Some people call it a probate avoidance trust.
Mm-hmm.
And you've probably seen some of those too over the years. In that situation, if you take everything you own and put that into your trust, then you own nothing at your death. Your trust does, and the trust handles the estate for you. You do not need to go to probate court.
Right.
The key is making sure everything's in that trust. And what I've seen more times than not is folks will have that trust and we're probating anyway.
Wow.
Because it is just so easy to leave something out of that trust. And I've also had a lot of clients who've come to me and said, well, I'm avoiding probate. I have a trust. And then I ask them, well, how's your home titled? And they say, well, it's in my name. It's like, well, you're not avoiding probate unless you put that home in your trust. Just because you do a trust does not mean you avoid probate. You have to fund your trust. You have to put all your assets in your trust. And again, it depends on your situation. If you have some kids that are wayward and you don't want to have to track them down when you file a will, or maybe you've got a family, maybe you don't have any kids. And Wanda, I can tell myself on this. I had an estate once when I first started practicing. I did a will for a very sweet little old lady. She's a great person. She passed away. She had no kids. She had no spouse. Her heirs were almost 30 individuals that lived all over the country. So 30. So in order to probate that will, we had to provide notice to 30 different people. And now I don't think she wanted to avoid probate or would have paid for a trust, but I was thinking now, like, well, heck, if I would have known that, I might have done the trust on my own dime just to avoid having to track down 30 people.
Wow.
And so that would have been a reason to avoid probate. When you kind of look ahead about, okay, what's probate going to take? I have seen situations where if your reason is cost savings, I've seen people spend more money to avoid probate than probate would have cost them in the first place.
Mm-hmm.
Again, that's just something to keep in mind. That's not the case for everybody. Again, everybody's situation's different. But when you're thinking through it, ask some of those questions. And, and when I have that probate avoidance talk with people, if you can easily do it, it's great. Doesn't hurt to do it. You just have to know what that cost is. And this helps kind of getting the word out about what probate truly is. Because I did have somebody that really, really would do anything to avoid probate, she said. And I asked her why, and she said, probate's really, really bad. And I said, well, why? She goes, well, it just is. That's what I've heard. And it's like, well, let's talk about it.
Mm-hmm.
And what's interesting in the state of Florida or California, when I have people move to Alabama from California or Florida, almost always they have a probate avoidance trust. They have one of these living trusts. Those are the norm in those states because probate a little more cumbersome.
Yes, I've heard that.
And I would say they're not, and there are other states like that too. I would just say it's not a bad thing to have them in Alabama, especially if you use them. It's not a bad thing if you use them.
Mm-hmm.
I wouldn't call it the norm or something that everybody has to have.
So I think it's important for those that are watching to make sure that they reach out to you for a consultation and not listen to what other people say. Just like the example you just gave, the lady that said she's heard, we can't always go by what we hear. So I just want to just add that I think it's always good just to have a consultation with a professional.
Well, sure. Yeah. Not just me. There's plenty of great legal professionals in Alabama. And, and it is, I've had people that have told me, well, my mother died and we didn't have to probate. So why are you saying we have to probate now? Now, again, sometimes we don't know the whole story.
Right.
When our friends tell us certain things, or they didn't have to do that, or they didn't, things could have been titled differently.
Mm-hmm.
Homes could have been jointly titled with a child. And I do want to mention avoiding probate. I've seen people do it this way, and it's dangerous. They say, well, I'm just going to put one of my children on my bank accounts, and I don't own a home anymore. So my account's just going to go to my child, and I'm going to avoid probate. That's true. That's correct. If all the assets pass outside, as a matter of law, you've avoided probate. But the problem I see is you're leaving it to a child, and legally the law says it's theirs. If they have siblings, that child has no legal obligation in most cases to share that inheritance. And there could be tax issues that come up with sharing an inheritance in that way. So I sometimes say that's okay. Maybe if all you have left is, a few $1,000s in a bank account, that may be okay. But if it's a significant amount, that can cause some problems.
Yes, because if that child owed the IRS, that
Correct.
could not be the IRS's money. Yes.
Or it's very dangerous to name, and talking again, somebody just this week they said my parents are going to name me as beneficiary and I'm going to manage it for these other people. And it's like, well, that's sort of like a trust, but it's not a legal trust. And the same problems could come up. And because if that same child who's holding that money for other people gets divorced or gets in a car wreck or gets sued in some business deal, that money is subject to those creditors and to that divorcing spouse. Whereas if you put that money into an estate or trust or to the proper beneficiary, it's protected. And so sometimes I tell folks, if there are easy ways to do things and there are simple ways, but those come at a cost. If you want to think about it, if it's real easy and doesn't take much, that's wonderful. But there's usually a cost of higher risk.
Right. And
if you want something safer, if you want your risk to go down, there's a little more cost and trouble on the front end. So, I've had to, you learn eventually you can't have it all. You sometimes got to pick and choose, your risk tolerance.
You get what you pay for.
That
Yes.
too. I mean, that too is like, I wish if there was a really simple, cheap, easy way to give you all the protection in the world and pay no taxes, I'd help you. I'd be glad to do it. I'll tell you the way to do it.
Right.
There's not. There's not. And it's just family by family. I think that's the other thing that's important too is, and take all this with a grain of salt. It is such an individual situation. I mean, each estate to me is different. When we look at that, every state has different issues. There might be lawsuits that need to be brought. There might be special types of assets. There may be business assets. So every estate is different and unique.
Mm-hmm.
And so get some guidance and going slow and moving slowly is important.
Mm-hmm. And how long have you been a probate attorney?
About 20 years.
Awesome. And you also do the estate planning piece as well.
We do. Yes.
Yep.
We do.
Let's see. My next question is, what's one of your most memorable probate cases?
It's there's a lot. I could speak anecdotally. Again, as lawyers, we don't get to share too much information, and maybe this is an amalgamation of some. Some of the more memorable come from poorly drafted wills. So I think this is kind of be careful on the front end with estate planning. I've had a couple of estates over the years where I've said to the family, I wish we didn't have a will.
Wow.
This will actually made things worse. And, those are some of the more, those can be really difficult because wills are very important. And when you write things down in the will, we have to do them or we have to navigate around them. So that could cause some memorable situations. If maybe it was poorly written, if maybe the client told the lawyer what to write and the lawyer just wrote it down, basically what the client said, and it didn't really make a lot of practical sense. Sometimes the will can make for a memorable estate. I think the assets can make for a memorable estate. I mean, a couple of things that I've had come up is, what do you do when someone dies and they own things that are illegal? And so dealt with estates with illegal firearms and trying to help navigate that with the family. My advice is don't keep them. Call the proper authorities to dispose of them. And I had in an estate situation once, I had to handle some drug paraphernalia. And I guess because, drug dealers have estates too. I mean, I guess they do. I mean, that's not a good thing to do. But the executor was a little worried when they found these illegal materials that if they were caught with them, they'd be arrested.
Wow.
And so we ended up helping them turn those over to the proper authorities. I guess for some reason, I thought it would be okay for them to bring them to me, which probably wasn't a good idea in retrospect, but I didn't know what else to do. But called some very nice law enforcement folks with Jefferson County, Alabama, and they took care of us, and they came and took all the materials away.
Wow. Maybe you need a reality show, Jack. That could be.
Well, one of the things I tell folks is a lot of times people say probate and estate work is boring. And gosh, I just don't think it's anything but, because really each estate, each probate, each estate plan, you're really working with a family, and my own included. We got some interesting things in the family. I mean, it's and people, it's just part of it, and it's just part of navigating life. And so, probate in that sense truly is, and it's an awesome opportunity to help families. And I know, Wanda, you feel that way too. I mean, you truly are navigating a transition in life. Yes. In a very, again, significant moment. And it's incredible to be a part of that. And with that is passing on a legacy and, your assets and your valuable possessions and your illegal firearms and, whatever you have. I mean, it's just part of your family's story. And part of that probate process is just moving that forward.
Wow. That is hilarious. Let's see. I think I have one final question. Does the Alabama probate process require legal representation?
Yeah, that's a great question too. And I've gotten that several times over the years. And usually I say yes. Now, there might be some counties, I understand, that will allow somebody to represent themselves pro se, which means you don't have a lawyer. In my experience, if you go to the probate court of any county around this area and you say you want to probate your mom or dad's estate, they're going to tell you to go get a lawyer. They might suggest a few to call, because to me, that does make sense. You want to make sure you have the right forms, and the court, it's easier on the court if you have the right documents, and a lawyer who does this a lot will know what to do. But I have heard of some folks being able to file the pleadings pro se. And if you're in a smaller county, maybe they don't have the volume of one of our larger counties, they may be more willing to work with you. But to answer your question, I think in most cases, you're going to be required to have an attorney.
Interesting. And I know that's different in every state. So that's why I wanted to make sure I asked that, since we're covering the Alabama.
It is. There's no statutory requirement or anything along those lines that I know of. But courts have a lot of discretion about what they accept, and so sometimes they can say, well, we need an attorney to file this for you. And on that sense, I mean, it could cost, and there are certain legal services organizations, volunteer lawyers. The Alabama State Bar has a good resource if you need some assistance with some pro bono help. It is difficult sometimes to find assistance for estate cases, because if you have an estate, that means there's some asset there, usually. However, you might have an estate where your sole reason to open it is because you want to be able to stay in your house and live in your home. And so I think there are opportunities with the volunteer lawyers program. Contact the Alabama State Bar, contact a local bar association. You may have a situation where you don't have the income or the cash assets to hire an attorney because you just have a house you're trying to save. And sometimes you need a probate process to do that.
Okay, well, this is awesome information. Is there anything else that you want to add that you think will be beneficial to everyone?
Yeah, I don't. I think I can't just state it enough. Doing the planning in advance. So much can happen, and one thing I want to touch on is when you die without a will, that probate process we just talked about is very similar, but there's a few more steps. It's a little more costly, and your assets may pass to somebody you did not want them to pass to. Because Alabama law has written a will for each of us. It goes to our heirs, and they determine who that is. And it's not necessarily what we would want. And so even a simple will, whether you go to an attorney or not, I mean, and Wanda, I've often joked with people, if I'm in a restaurant and you need a will in an emergency, I bet I could write a pretty good one on a napkin and get two people to witness it. I don't want to ever have to try to do that. So, but if I could, I think if it's a 911 situation, I could write a will quick. But you need something. And I'll just use the example, particularly if you're in a blended family, which is more the norm in a modern family situation. I had an estate once where husband had owned the home. It was in his name. He passed away, and he left a wife, and he left 3 stepkids. Well, what Alabama law says, and they were not her kids. Alabama law gives that house half to the wife, half to the stepkids.
Right.
And so she's owning a home all of a sudden, her home where she's been for a very long time, with some people that don't like her, and she doesn't like them. And it was such a difficult situation. That could have been cured immediately by either fixing that deed or doing a will. And even if that husband wanted to protect that home for his kids one day, he could have given his wife the right to live there, and then it could go to his kids. But as it stood, they had an equal right to be there, and they could force her out if they wanted to, and force a sale of that property.
Wow.
And that just stuck with me, because that was a lot of pain. There was a lot of emotion for that poor woman, that would not have happened had there just been a very, very simple will in place. And again, in that case, there were no assets to really fight over. The house was the only asset. And so, of course, if the kids wanted to get anything as a result of their dad's death, that was the asset they would get it from. So probate is almost always cheaper, more efficient, and just better conforming to your wishes if you do some pre-planning and have a will. That's the key.
Have a will. Wow. Okay, well, thank you so much for joining me today, Jack. Everyone that's watching, I have attorney Jack Carney here. He is an Alabama probate attorney. Please reach out to him if you have a probate situation or if you want to handle your estate planning. He is an awesome resource. I do have his website here. I'm going to put it on the screen, as well as his email address, and I will have a link. I will have his contact information as well in the description area of this video. This has been awesome. I have learned so much. I'm going to be looking in the restaurant for somebody that need a will. Yeah.
If you see me and you're in trouble and you have an emergency, just we'll do something real quick. We can make it work.
Yes. I always say, every person I interview, I like to leave with something that I think should be on a T-shirt. So maybe we can make that. Maybe we can come up with a slogan and that could be something on a T-shirt. Thank you so much for joining me today. You are amazing.
Great. Thank you. I had a good time.
Awesome. Again, thank you everyone for joining. My name is Wanda Rochelle. I am a licensed realtor and probate specialist serving Georgia, Florida, and Alabama. Please be sure to like the video and subscribe, and we'll see you on the next video.